Hi, for any of you followers out there to what's been going on with our case, we have some more information. Please like and subscribe too, so we can just get a little support here. We're amateurs to this, so we're just kind of putting some of this together, but there's a lot of crap that's going on, and it just keeps getting deeper, so we need to share our story. Maybe it could help some other people kind of wade through the criminal justice system and get a little justice for themselves. Hopefully, that's what we're hoping for. Just want to focus on a couple things today. I have some laws to go over. We have some paperwork from Morrison County that we thought was pretty interesting, to say the least, and some emails with our attorneys. So I'm going to start with an email that was between... oh, by the way, I'm Wendy. I'm a former special education teacher for 17 years, so I don't think that they like how I do some of my paperwork, but I'm pretty thorough. So, and my boyfriend is Mike.
Hi, y'all.
We've been together for 3 years, and it's been quite a roller coaster with all this going on. So if anybody could help us out, we'd sure appreciate it. And just thank you for listening. Here's an email from Mike to his attorney, August 20th, 2021. I'm willing to negotiate about the misdemeanor he spoke of, but a question keeps coming back to my mind, wondering about the sensitive evidence and why Miss Swisher, who is the prosecutor, has not revealed what it is. I request again to see the evidence that Miss Swisher is trying to suppress and has been withholding for months. The two motions that spontaneously came up while I was without counsel, and this was the beginning of June, was notified by email, then the court date was rescheduled for November. Could you please tell me about that before we continue with negotiations? It's sensitive information about me and my case, and I have the right to see it. It may affect my decisions. Thank you for your time on this. Lawyer David Buchan writes back that same day, August 20th. I will follow up with the evidence. This is at issue. If the judge has reviewed it and determined that it does not need to be disclosed, I may never find out what it was. I will check the status of that and let you know what I find out. Months go by, weeks go by, back and forth, don't hear much. We say, what's going on? September 30th. August 23rd, we said, what'd you find out? August 25th, he says, there's been no ruling on whether we're entitled to that information that has been submitted to the judge. We'll be making a request for the court to decide that issue. I will update this when we know the court's decision. Okay. Haven't heard anything. October 4th. Okay, so a month and a half later. Mr. Logreen, as you're aware, there's been an ongoing discovery issue involving one of the officers in this case. The state asked the court to determine if the information about this officer was something they were required to disclose. I still not know what this information is. After review, it is my understanding that the court determined that the information should be disclosed. In response, the state reviewed the charges and reached the conclusion that this information only affects the 4th-degree assault count. In an effort to avoid disclosing this information, the state has dismissed the 4th-degree assault count and has again asked the court to determine if it needs to be disclosed. I have attached a copy of the dismissal of that count and the letter that has been submitted. Part of the state's concern is that you will publish the information and cite some examples of things you have posted to support the concern. As noted above, I do not know what this information is or if it helps you with the other counts. I will continue to update this as I receive information about this, but if you have questions, please let me know. I also need to know the status of the plea petition and previously responded to your questions about it. Please let me know if you have any changes to make to that petition, because he wants us to sign. Okay, September 30th. Here's the letter that he's talking about. This is from Heidi Swisher, Assistant County Attorney. Dear Judge Wetzel, this office is in receipt of the court's order regarding the Brady material for one of the potential witnesses in reference to the above noted matter. Due to the court's disclosure order, this office intends to not call as a witness the subject of the Brady material and intends to dismiss count 2. The person who is the subject of the Brady material was not involved with the remaining counts. Based upon this information, and as further discussed below, I am requesting that the court reconsider its disclosure order and find that the disclosure of the Brady material to defense is no longer necessary. For the court's information, the state has a concern that if the Brady material is forwarded to the defendant by his attorney, the defendant will make it public. I have personally viewed YouTube videos posted under Mike and Wendy that the defendant posted, which includes postings of his recorded conversations with his attorney, Mr. Buchan, and portions of the squad videos from this incident. I did advise Mr. Buchan of the YouTube videos. Some titles of these YouTube videos include the following: Public Defenders Trying to Screw Mike and Wendy. Wendy is the defendant's girlfriend. Rob from Morrison County Public Pretenders. David Buchan, Loser Public Pretender. Failed to Identify Bad Cop. Minnesota Board Crooks think it's okay for cops to stand on people's throats. Snot Wonder Shit Public Pretender Loser. Shame on Sheriff Larson, Morrison County Squad Video. More Police Brutality, Excessive Force While Handcuffed Squad Video. And Cops Discrimination of the Mentally Ill. Given the above information, the concern about possible social media disclosure by the defendant that the state is dismissing count 2 and the state intention to not call the subject of the Brady material as a witness, I am requesting that you reconsider your disclosure order and find that disclosure is no longer necessary. In the alternative, I am requesting that the court restrict the dissemination of the Brady material. However, given the defendant's history, I am not confident he would follow any such order. I have, however, attached a possible disclosure order if the court wishes to take this route. Thank you sincerely, Heidi Swisher, Assistant County Attorney.
Isn't that interesting? My YouTube videos is what she's mad about, but my YouTube videos also got my count 2, 4th degree assault on a peace officer, dismissed, proving that the officer lied and I never assaulted him. They also have inside my house video footage of that same officer who lied and said that I assaulted him, choking me during my arrest while I was handcuffed and violating my due process rights and my constitutional rights. As well as Heidi Swisher and my lawyer and Wendy's lawyer, they're guaranteeing us that we're going to lose our trial. We want comments. Don't be afraid to leave comments.
Here is the letter that is the state's dismissal of the charges. One of Mike's charges was dismissed. Now they're also threatening to say that they could put that charge back on too if they wanted to, if we don't sign the petition. So they're threatening with that. Okay. Under the Brady rule. Sorry so it's the Brady rule, not the Brady law. The Brady rule says that the material or evidence the prosecutor is required to disclose under this rule includes any evidence favorable to the accused, evidence that goes toward negating a defendant's guilt, that would reduce a defendant's potential sentence, or evidence going to the credibility of a witness. Okay, so you just saw that witness, the credibility of that officer, he was dismissed as a state witness. So right there, that is part of the Brady material that they are trying to withhold. We believe, as Mike was saying, that if the information is revealed to us, it would reduce his potential sentence.
If not
Or
reduce my sentence, it would dismiss me or acquit me and acquit Wendy on all charges that we are being accused of at this point. This is what we believe.
Yes, we believe that video inside of the house absolutely showed not only Mike getting beat, and we do have pictures of that we've sent to the attorneys. They have those. We have us yelling,
get off his
hollering.
throat, all these other things.
My arm is hurting. My arm was hurt during my arrest as well.
And Morrison County Sheriff's Department and Minnesota State Trooper Daniel Owens used illegal chokeholds on me, and they're trying to suppress this evidence because that's what it's going to show.
And speaking of the illegal chokeholds, this is why we think it's so relevant. The current Minnesota law, 609.06, authorized use of force, subdivision 3, limitations on the use of certain restraints. A peace officer may not use any of the following restraints unless Section 609.066 authorizes the use of deadly force to protect the peace officer or another from death or great bodily harm. Remember, they may not use any of the following restraints. 1. A chokehold. 2. Tying of all persons' limbs together behind the person's back. 3. Securing a person in any way that results in transporting the person face down in a vehicle. B. This is important. For the purposes of this subdivision, chokehold means a method by which a person applies sufficient pressure to a person to make breathing difficult or impossible, and includes but is not limited to any pressure to the neck, throat, or windpipe that may prevent or hinder breathing or reduce intake of air. Chokehold also means applying pressure to a person's neck on either side of the windpipe, but not the windpipe itself, to stop the flow of blood to the brain via the carotid arteries. And then here's an email to Rob O'Malley, who is the manager, was that Mike, of Buchan?
Some branch of the public defender's office.
Mike said, talk to me about chokehold laws. It was in effect when I was arrested. Why won't Buchan talk to me about my constitutional rights? September 22nd, this year. It's been over a year, people. These are the laws. The laws are to reveal all exculpatory, inculpatory, and impeachment evidence. This is part of a constitutional guarantee to a fair trial. Brady versus Maryland 373 U.S. 8387, 1963. When there is reasonable probability that effective use of this evidence will result in an acquittal, Minnesota Court. Criminal Procedure Rule 9.01. Prosecution must disclose information. You can look up those different laws. I kind of mixed up some of them together. There is the Brady Rule. The Brady versus Maryland is the court case that talks about it. There's the Minnesota Court Criminal Procedure Rule 9.01, and that talks about how the prosecution is required to disclose this information. Why isn't she? What else can we do? This is what we're starting with for right now.
Please like and subscribe. Give us a thumbs up. Reach out to us in the comments. Tell us what you think.
Oh, can I add one more thing, Mike? This is pretty important, too. Our lawyers are not doing a thing about this. As we've said, asking them about constitutional rights, and they won't tell us anything. On the other hand,
they won't defend our constitutional rights.
My attorney cuts down and keeps threatening us that we're going to lose our trial if we do go to trial.
Mr. Scott Wonderlick.
So here's just an example of what we mean by threat. We don't mean to call extra names or anything accusatory, but I want you to look at this and see what you think. This just, remember, we did not have any weapons in this incident. We were peaceful. There was restraining order in place. The cops came in and beat us. There was a lot that went wrong. Okay, so my lawyer says, let me give you this fact scenario to illustrate why relying on an unauthorized use of force argument won't work as a defense. A man walks out into the street, pulls out a gun, and shoots 10 people, killing them all. Police officer runs out into the street, tackles the gunman, and uses a chokehold while trying to subdue and disarm him. The gunman is charged with A, 10 counts of murder, among other things, or B, nothing, because the cop used excessive force. The correct answer is A, Scott Wonderlick. That's my lawyer that's supposed to be defending me. So I said, Scott, are you sure you're working on the right case? You're calling us murderers? That is no defense lawyer. Quit so someone can defend me properly. So in that scenario, you're saying that Luke, the gunman, should have been choked, not Mike. And then cops didn't do their jobs correctly. Now I get it. And you still cannot state any laws. How many times do we have to tell you to stop playing games with us? We know what happened, and the whole world does too. The jury will love to hear this and will laugh in your face if you try to compare us to armed gunmen. We had no weapons, were peaceful as we stated to dispatch, and had a restraining order against Luke, who had a gun and came at us in the driveway. Request Brickyard Bar camera footage. Eric Hennigan said himself he could see everything we did in the front yard from that camera. That will prove again that we have been honest with everything since day one. Send me a plea in writing that we discussed. It's been weeks. Or schedule a meeting to discuss jury trial. Yeah, so now we're talking jury or petition, too. But they keep skirting away from the fact that they have evidence that they will not reveal to us.
We don't feel like this is a fair judge. We don't feel like we're going to have a fair trial. We definitely don't have fair lawyers or a fair prosecutor. Seems like all these cops and the judge and the prosecutor can break the law, but then they expect us to follow the law 100%, and they're telling us that we had no right to protect ourselves against someone who attacked us that we had a restraining order against.
And we reported him 5 times before.
So, yeah, is what it is. Thanks, guys.
Thanks.